How's it going, guys? I'm back. I'm making this video because a lot of people don't understand why I would rather file a motion instead of an affidavit or accept it for value or some kind of rescinding the contract type of deal. Now, I'm not saying those other methods work or any other method doesn't work. All I'm saying is I simply go by their rules. Now, a motion is an application for some type of order. That's the ultimate outcome. You want to get an order from a judge. And a lot of people will say, well, a motion is an application and therefore it's a request. Well, yeah, an application is a request. You're requesting the court to do something. Would you rather, and I've told this to many people that say, I'm going to file an affidavit. And I tell them, would you rather file a request for the judge to do something, and if he doesn't do it, then you can file a separate request for his boss to make him do something? Or would you rather file an affidavit which simply states facts of the case and requests nothing? And then they say, well, when you say it that way, that makes sense. Now, this is why I'm making this video, because a lot of people don't understand why I file motions. Now, an application is a request. When I file a motion for informal request for discovery, as you hear it in the title of the motion itself, it's a request for discovery from the prosecutor. I want him to give me everything he has that's going to be used against me in court. Now, if he says nothing and simply ignores me, like they will do sometimes, to see if you know what to do, I will then file a motion, which is a request, to compel discovery. So I'm telling the judge, Your Honor, I filed a request for discovery on this date. So much time has passed. Now, Your Honor, I am asking you, I am requesting from you to force the prosecutor to give me discovery. Then the judge will turn to the prosecutor and say, you are now being ordered by me, not by him, by me, the court, to hand everything over to the defendant. And if you don't, you will be held in contempt, which could include jail time or simply that the case be dismissed. Now, you see how that works? You are not going to battle the prosecutor, as pretty much everybody believes. That's not how it works. You are going to request that the court battle the prosecutor, in the sense that you're going to make them fight against each other through motions. Now, they're always going to, of course, not follow the rules or even follow the law. However, when you follow the rules will always give you a different type of remedy to deal with judges and attorneys that don't want to follow the rules or the laws. So there's always a way out for you. So keep that in mind. Now, I've had many people cry to me that they've told the court that their constitutional rights have been violated in their affidavits. And I simply tell them an affidavit is a piece of paper stating facts of the case. That's it. It's not a request of anything. Then they say, well, I filed at the bottom of it, I wrote, I move the court to dismiss this case in the interest of justice or because my rights were violated. And once again I say, however, it was titled and formatted as an affidavit, therefore it cannot be a request even though you made a request within the affidavit. It's not how it works. Courts have rules, and these rules govern everyone. Now, this includes the people being dragged into court by cops and the cops and attorneys as well. Everyone is to play by the same rules. Keep that in mind. So the court rules, the laws, the statutes, everything apply to everyone equally. So if the court rules say, for example, or even the Criminal Code of Procedures say, if the prosecution does not give discovery after a motion to compel has been filed, then the defense has so many days to file for sanctions. So as you can see, the law says the defendant is entitled to discovery. He or she has the right to discovery. But if the DA doesn't want to play, then you file a motion to compel after 15 days of filing an informal request for discovery. Now, if the DA still doesn't want to play, then he or she will be held in contempt. And those are the rules. Of course, they don't want you to know that. They want you to think as soon as you file a motion, you are giving them jurisdiction. But I tell you this, if they have no jurisdiction, folks, and you just simply don't show up because you don't have to, because they have no jurisdiction, isn't it true that they'll get a warrant for your arrest and arrest you at work? Or if you're just simply driving around, or maybe even come to your house? Well, of course it is. As a matter of fact, if you're driving around with a minor and they have a warrant for your arrest and they take you to jail and nobody can pick up that minor, they can even call CPS. So people really don't seem to understand how the courts can do a lot of things, whether they have jurisdiction or not. That's irrelevant, because when they do it, you'll find out that they're going to do whatever they want to do. So hopefully this video has helped you guys out, and now you understand why I file motions. And once again, motions are applications. It is an application. A motion is an application for the court to do something. It's just that. Just like an informal request for discovery, you're requesting something. An application is a request. Okay, folks? Thanks for watching. Please share this with your friends and family members so that everyone may be informed.